Thompson has been actively practicing law for over 45 years. As he calls it, his checkered career has included being a registered lobbyist in Washington, D.C., a chief deputy Los Angeles city attorney, and a partner in a 700-lawyer national law firm. However, for the past 25 years, Bob has practiced estate planning full-time in Fountain Hills, where he lives, and Scottsdale. With over 2,000 estate plans under his belt, Bob has dealt with some amazingly complex family situations, but he says he's still surprised with the new family dynamics he regularly confronts. But helping clients get their affairs in order is tremendously rewarding, and he has no plans to retire. He says if you love what you do, it isn't work. Put your hands together for Bob.
Thank you very much, and good morning. In today's Arizona Republic, for those of you who are familiar with the Gilbert cartoon, and it was somewhat relevant to my topic and very relevant to Mike Marone's topic, so I'm going to pass that around if you'd share it as I speak. I was asked to talk about transferring ownership when you die. That's the heart of estate planning. It is working it out so that your assets go as you wish them to go. And so the first thing people say, almost without exception, when they walk into my office is, oh my God, I want to avoid probate. Well, what is probate? At its heart, probate very simply is passing valid legal title of your assets to your heirs. But there are other vehicles for doing that too. But probate is a court process. It never goes as fast as you think it should, and it is not necessarily inexpensive. Now, Arizona, fortunately, we're not the worst. I know it'll come as a shock to you to know the two most expensive and complex states to do probate in are New York and California. But Arizona is not as simple as some of the states where all you do is put the will into the court packet and you're done. Well, we're a process that it's going to be hard to get a probate done much faster than 9 months. Typically, we tell our clients a year. So why avoid probate? Well, the cost, the expense, and it is a public process. So unless there is a family dispute, you're not going to have your assets known to the world unless you have a probate, because there'll be filings with the court. Do you ever want probate? Well, if you are a doctor or someone who might be subject to liability lawsuits, that probate offers a mechanism for terminating the rights of creditors to sue your estate or your heirs. So there might be a time for doing probate, but now fortunately we have a similar process available if you do what I'll get to at the end called a revocable living trust. So, must you ever make a will? Well, for young people who have young children, the will is the document that you must use to name a guardian for your children. So for young children, the will is a necessity, even if you do other things to pass your assets when you are deceased. Well, the most common question I get is, isn't there a way where I don't even need a will to pass assets? And the answer is yes. There are beneficiary designations that are available for almost every asset that you have. At a financial institution, at a bank, it's called pay on death, a form where you designate who you want to get your assets that are in the bank accounts. At a brokerage firm or a financial advisor's firm, they're called transfer on death. Two separate sections of the Arizona Code that do exactly the same thing. Why they're separate beats me, but they are. Then life insurance, of course, as you know, has beneficiary designations. Retirement accounts have beneficiary designations. Annuities have beneficiary designations. And in Arizona, we were the first or second, I'm not sure exactly which state, to enable you to pass real estate without a will or a probate using a document called a beneficiary deed. Some of you from other states may be familiar with the term transfer on death deed, but it does the same thing. It passes your real estate, any piece of Arizona real estate, not just your residence. And also, we now have a form with ADOT. You're a single owner of a vehicle. There is a form that you can use to pass the asset to your grandchild, your child, whoever you want to get it. So those forms are very, very useful. The problem with the forms, though, is what happens if you name your child is deceased, and then you want the assets to go on to the grandchildren, who are 3, 4, and 12. So if you have young grandchildren, you are going to have to ask the question of whether these forms really work for you. And that introduces the most frequent question that you must ask when you lay out your plans in a will or a trust. What if? That is the key. What if this doesn't work? What if that person is deceased? What if this issue arises for my children or grandchildren, such as a health problem? So the problem with these beneficiary designations, if you have 3 children, they're all adults, they have no grandchildren, and the form lays it out that it goes to the 3 of them or the 2 that are still living, works terrifically well. But if you've got young grandchildren, you've got a problem. Well, the state of Arizona will ride to your rescue, not unlike what Althea talked about. And by the way, I want to say that was a terrific presentation. And I just cannot emphasize so much what she said and the importance of getting the advance directives in place. But back to passing your assets. If you have no will, you have no trust, you've done no beneficiary designations, the state of Arizona has a system for you. Now, some people will say, oh, I don't want my assets to go to the estate, to the state. Well, basically, they're probably not going to. This system just lays out how the assets will be passed. And it is the way the typical family would want them to pass. To the spouse, then if the spouse is not there, to the children. If the children are not there, are the grandchildren. If there are no grandchildren, then believe it or not, we look up to see if the parents are still living. And if they're not living, then we look out to look for siblings or nieces and nephews if a sibling is deceased. So the system is really pretty logical if you have the perfect family and you want everything to go to those people. Okay. So I'll touch last on the Revocable Living Trust. The Revocable Living Trust, contrary to what you may think some attorneys are going to tell you, is not for everyone. But if the what-if questions get us tied up with the beneficiary designations, the Revocable Living Trust is sort of the gold standard for estate planning. There are 3 characters that play in what I call the trust sandbox. There is the person or persons who set it up. My documents, I call them the grantors because they're going to grant certain powers to the trustee. They're going to grant their assets, by and large, except for retirement assets, to the trust. Then there's who runs the show, who administers the trust. It is creatively called the trustee. And then who gets the benefit while you're living, you are the beneficiary. Those are the 3 characters that play in the trust sandbox. These documents are amendable, revocable. They are not subject to taxation. They are a complete pass-through entity. There isn't even a place on your 1040 income tax return to say that you have a revocable living trust. And yet, if your assets are properly titled in the name of the trust, they will pass without the necessity of probate.
May I ask a question?
You sure may.
Just very quickly, in the trust sandbox, I missed the first one. The second one was the trustee, and then the third one was you're the beneficiary. What was the first one?
I call mine the grantor. It's the person,
Grantor. Okay,
the person who sets it up.
Thank you.
Okay? So, is that the time?
Keep going.
Okay, so the revocable living trust is particularly useful if you are incapacitated in terms of handling your financial affairs. Now, I might digress at this point and say that a well-prepared estate plan that it has as a revocable living trust is probably going to have a total of somewhere around 13 or 14 documents. The trust is the main event. You still have a will to give you a seamless estate plan. So if you don't get assets titled properly in the name of the trust, and there had to be, God forbid, the probate, at the end of the probate, the judge just turns it over to the successor trustee, the person you named to manage your assets. You then will have an assignment of your personal property to the trust. Because in Arizona, the trigger for probate is $75,000 of non-real estate assets. And while used furniture isn't worth a heck of a lot, it doesn't take very much stuff, electronics, sporting equipment, collectibles, things like that, until you've triggered the probate. So it's typically a very generic document. It's my client's favorite document because it's one page long. It just says any of this stuff that we now own or hereafter acquire is owned by our trust. We then give you typically the forms to name any specific items of that stuff that you want to go to any specific people. And that, at that point, can include cars, assuming you've got them titled into the name of the trust. If they're titled in the name of the trust, you can put cars on that list of personal property. Then you have what we call the side documents, not to minimize their importance in any way, but the backup will, as I mentioned, the financial power of attorney, the healthcare power of attorney, and in my form, we have a separate document called a living will. That is the end-of-life document that virtually everyone will execute. There's also another end-of-life document called a Do Not Resuscitate Form. Frankly, unless you're terminally ill with pancreatic, I'll get it out yet, stage 4 pancreatic cancer, or you're 104 years old, I am not a big fan of the Do Not Resuscitate forms. I think they are too draconian and too final. Properly done, advanced directives, I believe, give your heirs the guidance that you want for end-of-life decisions in a much better way than the Do Not Resuscitate. And so I think I've ticked off the, then we generally will do the deed transferring your home into the trust. So I think I've gotten up to somewhere around 9 to 13 documents there. And that is the complete package that I would suggest that most people are going to be interested in if they have estates in the low 6 figures or higher. What about avoiding estate taxes? Well, very simply, and I guess, am I stepping on the accountant's presentation here?
Go for it.
Okay, well, the estate tax exemption, as we sit here today, per person, is a mere $12,060,000. That's indexed for inflation.
And if that's your problem, talk to me.
However, a warning for those of you that are reading easy because you're in the 6 to 12 million category, as of January 1st of 2026, that exemption is going to drop to about 6 million apiece. So for 99.9% of the population, those exemption amounts are probably sufficient. There is no Arizona death tax. There is no death tax in California. In California, it's in the state constitution. In Arizona, we would be cutting off our nose to spite our face to tell seniors that bring all their money here, we're going to tax your assets when you die, because seniors are a wonderful thing for state budgets because they use so little government money. Aside from an occasional EMS, they don't have kids in school, they do drive on the roads, but they don't drive as much typically as everyone else. So we want seniors to come here, and Michael especially wants them to come here. Okay. So So that's it. I'd be happy if I have a few more minutes to
You
answer.
have a minute and 30 seconds, Bob. Good
Can
job.
I ask a quick question? What, in regards to the estate taxes, if I was a snowbird, how would it be determined on which state my estate would be filed in?
If you were a snowbird, permanent residence would be typically 6 months and a day. If you are a person who has moved here, even though you've left your financial accounts and in spite of Micah's best efforts not moved them here, and they're still back in Minnesota or Wisconsin or New Jersey, they're going to be treated here as your state of residence. Haven't figured out a way to move real estate from those states here. The importance of that, by the way, is for a couple very quickly, that if your assets are properly titled, you're a couple, on the death of the first spouse, the assets, other than retirement assets, will get a basis adjustment for capital gains tax purposes. So if you bought your home for $300,000 and it's now worth $560,000 when the first spouse dies, the new basis for capital gains tax purposes for the surviving spouse would be the value as of that date of death. Other question?
Is that true also if you're not married, that whoever inherits the property, it will be the higher dollar amount?
Yes. There it is.
Is that true, no matter which way you title the home?
No.
That high is,
It has to be properly titled. If it's not in a trust, typically the trust should have what I call a community property assumption. It says anything that is here in this trust that's titled in the trust should be treated as community property. If you own your home outside the trust, you want it, and you're married, you want it titled community property with right of survivorship. The old way is, well, it's still very good if you're not married, is joint tenants with right of survivorship to avoid probate. But the community property with right of survivorship is important. Yes?
Can you give a ballpark figure for how much it would cost to set something like this up?
The answer is...
It depends.
Turn the cameras off.
No, I was happy to bring that. For a single person, you're probably looking in the range of $2,500. For a couple, you're probably looking somewhere around $3,250, because there's a second set of documents. And that includes the letter, the funding instructions, working with you to get assets titled in your trust. That includes titling the real estate. That includes a whole bunch of copies of your advance directives. They don't do any good stuck in your trust notebook or your file cabinet. We want you to distribute the advance directives to the people, obviously, you're going to make the decisions, to your doctors, one to take with you if you go to the hospital, one to throw in your luggage when you take your world cruises, and a set for the glove box of each of your vehicles. In addition, in Arizona, there is a state registry for your advance directives, which we put our clients into, and they will issue you a little card that has your passcode and your, what's the other thing you have? Passcode and user ID, login. And so anywhere in the world, doctors or hospitals can go online, they can get a copy of your advance directives. So we take care of that for our clients as well.
Bob, if that registry, doesn't it have to be the state forms or, legal? You couldn't put 5 wishes in there.
Sure you could.
Oh, you can?
Yes.
Is that
Yes,
new?
there is a cover page that goes with all of it, but you can put whatever your directives are.
Excellent. Thank you.
Thank you very much.